Today's presentation is about sex discrimination by Tramiel Anderson from the employment law class. In the past, sex was considered a bona fide occupation qualification. Stereotypes ruled. Physicians, lawyers, construction workers, and police officers was the following men's job, and nurses, flight attendants, secretaries, and teachers were the following female jobs. Both men and women should be treated equally in the workplace in all aspects of employment, hiring, compensation, training, transfer, and promotion. Sex discrimination is when individuals of one gender are favored in employment decisions over the other gender. Title VII protects both men and women's sex discrimination rights. Discrimination may occur against an individual not solely because of his or her gender, but the fact coupled with another may be its cause. This is called sex plus discrimination. Here are some examples of sex plus discrimination. Women with small children, women in childbearing years, women taking care of elderly parents. BFOQ, also known as bona fide occupational qualification, is a defense to a suit for discrimination with regard to religion, national origin, gender, or age. The first three defenses are found in Title VII, while the age of the bona fide occupational qualification is found in the Age Discrimination in Employment Act, also known as the ADEA. Courts have constructed this defense, limiting it to job requirements that essentially to the job or are the core purpose of the business. The Equal Pay Act of 1963 is an amendment to the Fair Labor Standards Act, which regulates the following: child labor, minimum wage, and overtime pay. The Equal Pay Act prohibits the payment of different wages to men and women who are performing the same jobs. This act covers all types of job categories from clerical to executive. The job must be equal with regard to skill, knowledge, or experience, and the conditions under which the work is performed must be similar. Here's an example. A person working overseas is entitled to a pay differential for the same job performed domestically. Comparable with is an attempt to assign values to male-dominated and female-dominated jobs based on worth. Where the values are equated, equal pay is required. The theory behind this doctrine was that most female-dominated jobs pay less than male-dominated jobs. This argument has not found the court's favor because assigning values is arbitrary and interferes with payments based on supply and demand. Dress and grooming policies. When an employer attempts to regulate grooming length of hair, beards, and mustaches, it has been in favor of the employer. Reasoning being that grooming codes are more closely related to the manner in which an employer decides to operate its business than to equal opportunity. Good grooming standards have always been required in the business. Arguments against grooming codes have come up in the form of First Amendment rights of speech through personal expressions. The 14th Amendment Equal Protection Clause in Title VII provisions regarding terms and conditions of employment. Imagine walking into a bank and the branch manager who has not shaved or showered and is wearing jeans and a wrinkled shirt. The customers will lose confidence in the bank and move their accounts elsewhere. That kind of appearance is not allowed because it wouldn't be a good business policy. Here are a few sex discrimination cases that I came across while reading the chapter. Brina Lewis versus Heartland Inns of America. The issue in this case is whether sexual stereotyping is permissible in the workplace. Brina Lewis ended up winning this case because the employer used sexual stereotypes to later use it as an excuse to discharge her. This is one of many forms of sexual discrimination in this case because she was a female. Laurie Chadwick versus WellPoint Incorporation. The issue in this case is whether Chadwick was overlooked for promotion because she had small children. The judgment was sided with Chadwick because she proved sufficient evidence that she was looked over because she had small children. This is also a form of sex discrimination, a mother with kids. Tracy Lurz versus Sealy Incorporation. The issue of this case is whether a supervisor can make a stereotypical assumption in deciding to award a promotion to a man over a woman. The judges sided with Tracy Lurz. Sealy Incorporation had to pay Tracy over $150,000 for damages following this case. This is another form of sexual stereotyping. Lastly, Pollyann Heller versus Elizabeth Ford School District. The issue in this case is whether the school district had a valid explanation for paying younger male teachers higher salaries than it was to pay 3 female teachers who were over 50 years of age. The judges sided with Polly and Heller because the school district explanation was invalid, which means the district is guilty of violation of the ADEA and Equal Pay Act.